That's correct. We attempted to get information before that. I mean, Ms. Wilson and I did, but we were thwarted by the administration. So,
This letter is dated November 25th of 2008, right?
that's right.
And this letter is from Eddie Moore to Henry McMaster. And it's asking Mr. McMaster to start an investigation into Mr. Preston as early as November 25th of 2008.
Yes.
And on this email, or letter, this email, up above, you see the blind copy field.
Let me see. Yeah, I do.
And in that blind copy field, it's true, is it not, that WAIM radio's email address appears.
Right.
And that WAIM radio, that's Rick Driver, right?
Yes.
And also in that blind copy field, you see an email address that's southernboy@charter.net. You see that?
Yes.
Do you know whose email that is?
Do I know who that
Do you know whose email that is?
is? Southern Boy? No, it looks like it's an abbreviation. It's SUTH Boy. No, never heard of it.
Okay. How about the county clerk's email? She's blind copied, isn't she?
Yeah, I see that.
And up above, your copy and Mr. Allen's copy, correct? I'm sorry, you
See if
said
I
you didn't
can
know that.
read all this.
Your copy up above, right?
Okay, yeah.
And then, in the third sentence of his email, Mr. Moore writes, and I quote, "The new majority of Anderson County Council, 5 members of the 7th, that takes office on January 1, 2009, would like your help with what happened at," I think it means our, I think it's a typo, "at OUT meeting on November 16, 2009, end quote," which is also a typo because it should be November 18th of 2008. But the question I have for you is, as of November 25th of 2008, Mr. Moore has sent an email to the Attorney General asking him for his help, along with the majority of the county council, for January of 2009. And that's what that document reflects.
Yeah.
Mr. Moore, Mr. Waldrep, sorry. Can you turn to Defense Exhibit 50? Mr. Waldrep?
Yeah.
Are you at Defense Exhibit 50?
Yeah. I'm on.
Oh, do you need more
I
time?
got you.
Mr. Waldrep, is this the order that was granted by Judge Nicholson on December 29, 2008, wherein he granted an injunction against you from you, and that injunction was to enjoin you from interfering with the county administrator's duties any further? Correct?
That's correct.
In that first paragraph, second to last sentence, it reflects, and I quote, "A motion hearing was held at Anderson on Wednesday, September 24th of 2008, end quote." Do you see that?
What page are you on?
The first page.
Yes.
And September 24th, 2008 was actually the day just prior to when Anderson County received the letter from Mr. Hoskins putting the county on notice of his claims against the county. Was it not?
The dates coincide, the dates speak for themselves, I guess.
This order issues approximately 30 paragraphs or 31 paragraphs of factual findings against you and Ms. Wilson, does it not?
Yeah.
And in particular, paragraph 27 states, and I quote, "The county administrator's duty to supervise his employees is being intentionally and purposely thwarted by defendants," end quote. That's what Judge Nicholson found.
That's what it said.
Paragraph 29, second sentence. Judge Nicholson found, and I quote, "The actions of defendants have interfered with the county administrator's ability to do his job," end quote. Correct?
That's correct.
If you turn the page 2 pages from there,
Which page?
2 more pages.
Okay.
May I approach you?
You may. This one's actually a little harder to find. So.
We have the number. Okay.
Two pages later, below the block quote, and as the showing, to support a preliminary injunction, Judge Nicholson found, and I quote, that the plaintiff, Mr. Preston, has shown he is likely to prevail on the merits in this case. And
Right.
that's what he found, right? If you'll turn, sir, to the last page, or the last exhibit, which is Defense Exhibit 51. This exhibit reflects fees from the Richter Law Firm, correct?
Yeah.
And that's you. Those were your fees, were they not?
Yeah.
And those fees were paid by the county, were they not?
It works.
And they were paid by the county because at some point the county council agreed that when you were doing the things reflected in Judge Nicholson's order, you were acting in your official capacity, right?
That's correct.
So the county agreed to pay your fees because in the instances of interference in that order, you were acting in your official capacity.
I want
Mr. Waldrep, it's good to see you again. I wish I could have seen you under better circumstances. Thank you for your time.
Redirect.
Thank you, Your Honor. Mr. Waldrep, if you look at Defendant Exhibit 50, the one you just had a moment ago, the temporary injunction order,
to. Yeah.
was there ever a hearing on the merits in that case? They talked about a hearing on the merits.
Yeah, there was no merit on the case because we were never afforded to put up a response to this case. Judge Nicholson had not terminated the case, but he had listened to the plaintiff's side, and we were never able, given an opportunity to respond.
The document in front of you, Defendant Exhibit 50, is a temporary injunction, is it not?
That's correct.
Was a permanent injunction ever issued?
No, I don't think he could do a permanent injunction.
And what happened with this particular lawsuit?
It was dismissed, the county dismissed it later on.
Thank you, that's all I have.
Your Honor, just one.
Isn't the reason, sir, that a permanent injunction was in fact not issued because when the new council took office in January of 2009, they instructed Michael Cunningham to dismiss that case?
objection, Your Honor. It calls for speculation as to what permanent
As a
injunction.
member of council, he can say whether he knows. I don't know the answer to that question if he doesn't know. So I would ask the witness to answer of his own knowledge.
I think a request was made to Mr. Cunningham to dismiss this action, and then he declined to do so for a while. And then later on, he did comply with that request and dismissed the action against him and Ms. Wood.
Thank you for your time, sir.
Anything further?
No, Your Honor.
Sir, you may step down. Thank you very much.
I have to leave.
Sir, you wish to leave?
No, sir, I said, do I have to leave?
Well, witnesses are sequestered, so you're going to have to step outside.
Your Honor, we were going to ask whether or not he can be released. I don't know. Preference on that. We don't intend to call.
Excuse the witness from any further participation.
I'd be glad to excuse you, Mr. Walker.
All right, so you're excused. You can stay, but I will caution you will remain under the order not to discuss your testimony.
Not to say anything. all right?
Yes. You can have a seat in the court. State may call us next week.
Anderson County calls Thomas Bright. I believe Mr. Bright is present.
Did you call Mr. Bright for me, sir? Thank you. Mr. Bright, you'll come forward and be sworn right here in front of you. Thank you, sir.
Please raise your right hand. Do you solemnly swear affirm testimony you give the court today in this case to be the truth, the whole truth, and nothing but the truth? I do. If you would take a witness stand and state your name and spell your last name correctly, please. What those steps, please.
My name is Tom Bright, B-R-I-G-H-T.
Mr. Gentry, your witness.
Thank you, Tom.
Yes, sir.
Good afternoon, Mr. Bright.
Gentry, how are you today?
I'm well, appreciate your time. Tell the court, if you would, what you do for a living.
I am a practicing attorney.
Where did you get your bachelor's degree?
I got my bachelor's degree from a small state school in Pennsylvania, Clarion State College.
When was that?
That would have been in 1978.
And where did you attend law school?
University of South Carolina.
When did you graduate?
I graduated in 1981.
All right, sir, where are you currently employed?
I am employed by the Ogletree Beacons Law Firm in Greenville, South Carolina.
Are you a shareholder there?
Yes, I am.
How long have you been practicing with Ogletree?
I've been practicing with Ogletree probably for about 5 years, maybe 6. But I actually practiced with a predecessor firm that is now merged into Ogletree for about 23 years.
Does your practice have a particular focus?
I have practiced almost exclusively in the field of labor and employment law for the 31 years that I've been practicing.
All right. Have you had any involvement in the course of your career in the labor and employment section of the South Carolina Bar?
Yes, I have. I've been a member. I was a member for a number of years and held several positions.
Were you president at one time?
I'm sure I worked my way up all the way through programs manager, through secretary, and eventually became the president of that section of the Bar Association.
Mr. Bright, do you recall being engaged in the fall of 2008 by Anderson County?
Yes, I do.
And are you able to testify today about that engagement?
As best I can remember, yes, I will.
All right. Is the attorney-client privilege a barrier to your testimony?
It is not in this case simply because the county at one point in time actually provided me with a written waiver of the attorney-client privilege, which would ordinarily prohibit or impede a lawyer from discussing anything that he had his retention by a client.
May I approach the witness?
You may.
Mr. Bright, I'm handing you what's been pre-admitted as Plaintiff's Exhibit 10. Do you recognize that as a copy of the waiver that you mentioned?
Yes, I do. This is it.
Thank you, sir. What, in general terms, was the nature of the engagement with Torrey Anderson County in 2008?
And I can't remember if it was early October, which I think is the time frame of 2008. One of my partners received a telephone call from the county. It involved Mr. Joey Preston and a letter that his lawyers had sent to the county, and we were retained to give the county advice with regard to that letter and the relationship with Mr. Preston.
May I approach the witness?
You may.
Mr. Bright, I'm now going to hand you what's been pre-admitted as Plaintiff's Exhibit 12. Ask you if you recognize that and can identify it.
This looks like the initial contact with our law firm through Buddy Daniel from the county council, and then it's also a letter to me saying that we have been retained.
And what's the date on the communication to you?
The communication to me from Mr. Thompson, who was the chairman at the time, was October 8th, 2008.
And is that consistent with your general recollection about the time that you first got involved?
Yes. Yes, it is.
All right. Let me ask you to look first at the message from Mr. Thompson to you. The first thing he does is wish you congratulations, which in hindsight is interesting. How does Mr. Thompson in the next paragraph characterize the claim that Joey Preston is making?
He characterizes it as a contractual claim.
Look, if you would, at the paragraph below that. What does Mr. Thompson say to you in this email about the desired timing of the handling of this matter?
He makes the point that there's only 4 meetings council left before the new council is to be seated. And he says time is of the essence.
The third and fourth pages of Exhibit 12 are a copy of the letter on Foster Law Firm letterhead dated September 25th, 2008. It's on the fourth page. It's signed by Rob Hoskins, and the letter has a number of addressees. Do you remember receiving this letter as part of the communication from Mr. Thompson?
I remember this as being a part of the initial contact with our law firm, yes.
What is this letter? Do you recall?
It is, and again, I can read it and tell you, I can tell you what my recollection was, is that Rob Hoskins was representing Mr. Preston at the time, who was the county administrator. I believe the letter reflects that several people had made some comments on the campaign trail that year who were running for county council.
Let me direct, I'm sorry, did you have?
That's all right, go ahead.
Let me direct your attention to the first 3 or 4 lines of the letter. There's a statement there from Mr. Hoskins regarding the time frame in which he says actions are expected to take place. What's his statement there?
It's basically saying that newly elected council members intend after January of 2009 to prevent Mr. Preston from carrying out his duties as the county administrator.
All right. If you look down about 4 lines from there, after talking about what Mr. Hoskins characterizes as attempts to hinder Mr. Preston's ability to perform his duties, there's a sentence that begins "those attempts." Would you publish that sentence by reading it into the record?
Those attempts have, thus far, been most unfortunate for the people of Anderson County. But Mr. Preston has overcome the efforts of those who would stymie him in the performance of his duties.
Thank you, sir. In this letter, this September 25th letter from Mr. Hoskins to the members of County Council, is there any statement that the current council as a body had taken any adverse employment action against Mr. Preston?
The focus of the letter, and you can go down about 4 more lines, Mr. Preston considers the intent of certain members of council and their allies to prevent him from performing his jobs. And he looked at that as an anticipatory breach of his contract. But the focus is on the people that had been elected and would be coming into office.
So the expectation of what might happen in January 2009?
Just that they would do something to terminate his employment.
But there was no description of any current wrong by the current council?
No, Rob Hoskins used the terms anticipatory breach, which means anticipating a breach of contract at some time in the future of his employment contract.
Do you recall, after receiving this email, Exhibit 12, from Mr. Thompson, when you first met with someone from the county?
I couldn't tell you what the date was. I could tell you that I most likely had a telephone call with someone from council, most likely Mr. Thompson. I know that the first meeting that I had was with Mr. Thompson.
And was that after the receipt?
Was after the receipt of this letter, yes.
Do you recall having a conversation with Mr. Hoskins in around this same time frame?
I'm sure I would have, because it would make sense that as someone that's been asked by Anderson County to respond to a letter that Mr. Hoskins had wrote. Mr. Hoskins and I live in the same town, we run in some of the same circles, he and I know each other. So it would have made sense for me to have called him as a courtesy to say that I was going to be involved.
Do you recall how Mr. Hoskins characterized generally what he was trying to accomplish with Mr. Preston?
I know that...
You asking for what Mr. Hoskins said?
Yes, Your Honor. As he's a representative of the party opponent, it would be an admission of the party opponent through his attorney.
He's right about that.
I think he is right about that. You may proceed.
Again, I don't remember the specifics. I do remember having reviewed my file at some point in time that there is a handwritten note